This isn't about relitigating a 2021 trial. This is about what happened after and why a new court order in 2025 restarted the appellate clock. Georgia law is clear. Under Chambers versus State, when a trial court issues a new substantiative order, the order is independently appealable, even if the underlying case is old. It doesn't reopen the trial. It opens the door to review the new ruling itself. On October 29, 2025, Judge G.E. Bo Adams issues a new order titled Order on All Pending Motions. Now, let's be clear. Dexter Williams' trial ended in 2021. This order is not part of the trial. It is a new judicial action. By ruling on all pending motions, the court created a fresh appealable event under Chambers. 5 days later, on November 5th, 2025, Dexter files a notice of appeal. This appeal does not relitigate guilt or innocence. It appeals only one thing, the October 29th, 2025 order. That matters because the state cannot expand the scope of an appeal beyond what the defendant actually appealed. Instead of responding to the merits of the new order, the state reframes the appeal as if Dexter is challenging everything. That's not what the notice of appeal says. That's not what Chambers allowed. This is how procedure gets weaponized by turning a narrow appeal into a procedural dead end. On February 3rd, the appellate court dismisses, not on the merits, but on procedure, not ruling on whether the October 29th order was lawful, not ruling on whether the trial court had authority, just procedurally shut down. All right, what this document is, this is straight from the Georgia Supreme Court. This document is not a ruling on the merits of Dexter's case. It is not a finding that the conviction was lawful. Courts do not use that language when they have a complete certified record. They use it when the record is incomplete. They use it when the court is relying on representations, not documents. They use it when the court is hedging because it does not actually have jurisdictional certainty, right? They are speaking without the full file in front of them. This is what they're assuming and not proving. They're assuming that there was a valid superseding indictment. They're assuming that the superseding indictment properly replaced the earlier case. They're assuming that procedural posture flowed cleanly from one case number to the other. They're assuming that the sentencing aligns with the correct indictment. They assume that the appeal posture bars review. But see, here's the problem. There is no null pros entry on the 55-430 docket. There is no sentencing order on the 56-788 docket. There is no trial transcript for the 56-788 docket. There is no arraignment on the alleged superseding indictment. There is no open court notice of dismissal. There is no jury reset. There is no certified transfer showing continuity. So the court is accepting a narrative, not adjudicating facts, right? This order is doing three things only, right? It's narrowing the scope of review because they're saying we will only look at what the appeals appears to challenge, not what actually happened, not what the full record would show, only what fits into the procedural box they're comfortable to fit in, right? Also, they're avoiding the merits. This is exactly why it keeps saying it appears. Because if they said the record shows, they would be lying. Why this matters legally? When an appellate court decides a case without a complete record and it's based on assumptions, while refusing to compile the missing record and while procedurally barring merits review, that is not a neutral error. That is a structural due process failure. And in Joyner versus Leaphart, the Georgia Supreme Court warned courts not to misuse procedural rules to avoid addressing substantial rights. Joyner makes one thing clear: procedure cannot be used to erase review when a court creates a new legal consequence. That's exactly what happened here, right? This appeal was never about 2021. It is about the 2025 judicial action. By refusing to address the merits of the October 29th order, the system keeps firing cases upstream while never answering the core question. That's not justice. That's the Georgia Railroad.